For there to be a right, there must be a wrong committed, because, and as we all know, there is no wrong without a remedy. Good day, everyone. My name is Jesutofunmi Olajide, a law graduate of Ajayi Crowther University and a Batch C graduate intern at HARLEM Solicitors. Today, I clarify and elucidate the topic, legal rights and remedies of telecommunication subscribers. By the end of this lecture, a non-professional should be able to deduce and understand what it intends to achieve. And it also aims to add to your already own knowledge and give you a better understanding of what you do not know, so that the next time a telecommunication provider fails in performing their duty, you'll be equipped enough to know your rights as a telecommunication subscriber, and you'll be able to seek redress when such rights have been violated. Moving forward, I will be defining the key concepts. Firstly, telecommunication refers to the exchange of information through electrical and electronic means over a significant distance. Now that the definition has been established, I will be moving to telecommunication service provider, which is which without it, the usage of telecommunication will not be possible. Telecommunication service provider means and includes cables and equipment installation, contractors, system operators, and any other entity that helps in the provision of telecommunication service. Telecommunication service, according to the International Telecommunication Union, is the general name for service provided by or over a telecommunication network. Now, I'll be moving to the principal legislation of telecommunication in Nigeria, which is the Nigerian Communication Act, herein refers to as the NCA 2003. The NCA 2003 established the Nigerian Communication Commission, herein refers to as the NCC, and this is the sole regulatory body of telecommunication in Nigeria. One of the primary objectives of the NCA 2003 is to protect the rights and interests of service providers and consumers within Nigeria, and this can be seen in Section 1, Paragraph G of the NCA Act. The NCA Act. The NCA Act also established the function of the NCC to include the protection and the promotion of the interests of consumers against unfair practices, including but not limited to matters relating to tariff and charges for and availability and quality of service of communication service, equipment, and facilities. To elaborate and assist this act, the NCC is empowered to make regulations and guidelines, and this is provided for in NCA 2003. The Consumer Code of Practice Regulation, herein refers to as the CCPR, was established to contain consumers' code and practice in the telecommunication industry. It is pertinent to note that in any business or commercial transaction, there is always a form of exploitation from the part of the person providing the service. This is to tell us that we need to know our rights and duties, and these rights must be respected. Consequently, Consumers Code is established with the function of preventing exploitation and allowing consumers have optimal satisfaction of the service that is available in the market. Hence, the telecommunication provider owes the duty to the subscriber to make sure that they are enjoying the benefit of the product they have been charged for. Moving on, I'll be talking about who a consumer or a subscriber is. In the NCA 2003, a consumer or a subscriber is seen as a person that subscribes or uses communication service. Section 4, subsection B, subsection C, and subsection H of the NCA 2003 give the right of protection of the consumers to the Commission to make them to be able to protect the rights of individuals against unfair practices of the licensee and any other person in charge of telecommunication service. The rights of telecommunication users include but are not limited to the right of information, the right of quality of service, the right of bill charge and accruement of bills, and the right of privacy and information of an individual. These rights, as we all know, that there is without when we have rights, there must also be remedies, because when those rights have been violated, it is remedies that will be used to actually make sure that those rights will not just go unpunished. The remedies that can be sought by any telecommunication subscribers that their rights has been violated are monetary compensation, relief, reforms, and probably going to the courts. But it must also be noted that when these remedies are taken, they have stages in which they can be taken. It must first of all go through the telecommunication operator. This means in a situation where Intern, for instance, have breached their duties to you or do not perform your right to you, you first of all have a negotiation with them. When the negotiation does not now go through, you will then go to the commission, which is the NCC. This NCC is already empowered by the Act to go through these terms with you. In going through these terms with you, if you are not still satisfied with what the NCC does, you can then go to the court, as the court is seen or should be seen as the last resort when you are dealing with your rights in the telecommunication industry. This is to tell us that our rights and remedies are really important for us as telecommunication subscribers. I will leave us with this: Ibu jus ibu remedium, which is you cannot suffer a wrong without a remedy. So for every wrong that you have been suffered, or for every time your right has been infringed upon, there is a remedy. I hope that this lecture has educated you and you are able to take one or two things home. Thank you so much, and for more information you can visit www.harlemsolicitors.com and also follow us on our LinkedIn profile. Thank you.